Immunity, where does it lie? In the sea of power or the watchful eye? Justice seeks the truth through layers and lines. In the balance of power, our faith combines. A president's duty, a nation's gaze, decisions that echo through future days. Can actions be hidden behind the shield, or must the truth of justice be revealed? So we watch and wait as history's penned by the highest court on which we defend. For the rule of the law in the light of day, guiding us forward, come what may.
Brett, thank you so much for being on the program. What a day. Given your extensive experience and decades of prosecution for the federal government, do you think the Supreme Court got it right here in the 6-3 decision?
Yeah, I would say the Supreme Court got it right, and it's a little heartbreaking to see 3 justices of the Supreme Court not joining this, because the law is so established, and the analysis that was used by the majority in this case is bulletproof. It's sound, and it was reasonable. And what I mean by that, Benny, is it did not just simply grant immunity to Donald Trump. And it can't do that. That's not what the court does. The court is a court of final review and not one of first review. So what the court is in essence saying, here's your immunity. It's broad on constitutional authority, and it is presumed on any official acts. That's such well-established law, Benny, that it's incredible, a win for the country. I think Donald Trump is right. It does root us back in the Constitution, but how scary that 3 justices weren't able to reach that conclusion. And it tells you there's still politics in the Supreme Court.
I apologize for putting you on the spot, because I know this ruling came out 15, maybe 20 minutes ago, but have you read the dissent? Do you know what on earth? I assume this is the far left wing of Jackson, Sotomayor, and Kagan. Am I correct there?
Yes, it is.
Have you? What on
yes.
earth? What could they possibly have? Is the reasoning that? So did they start off their dissent by saying that Barack Obama should go to Guantanamo, should be put in Guantanamo Bay for murdering an American teenager with a drone? Is that how the dissent started?
Well, in essence, it is the unbelievable position, especially coming from the left, that they want to rein in presidential immunity. They've never taken that position ever. In fact, they've taken the opposite position. But in the dissent here, what they're in essence trying to argue is that the official and unofficial acts where the majority draws a very big line, they want to engage in broadening what unofficial acts are, and so they want to strip immunity and broaden unofficial acts, so that the president, for example, the Supreme Court said in the majority, him talking to the Department of Justice, which is a major part of Jack Smith's allegations that he was conspiring to pull down the election, him talking to the Department of Justice is absolute immunity, because it falls directly within his constitutional powers to have the conversation with his own branch, and he's the head of the executive, right? So the dissent doesn't want to recognize that, and they don't want to recognize the breadth of it, and I think that's dangerous. It should apply as equal to a Democrat president as it does a Republican president, and right now this. A lot of people are going to say on the left, Benny, they're going to say it's not as big a win as you think, because the federal prosecutors can go back, and now they have some guidance, and now they'll be able to argue with a friendly judge which facts are unofficial and which are official. But that's not entirely true. The majority opinion indicated one thing that I don't think a lot of people are going to talk about. They said that they cannot introduce the president's motive behind what he may have said or done. They can't introduce evidence of motive. And that is fascinating to me, because what they're saying is you cannot have facts and then introduce evidence of what you think the president's motive was, and then claim that those are unofficial acts. You have to actually have unofficial acts on their face. So if he went out in the street and he got a gun and he shot somebody, that is obviously an unofficial act. We don't have those facts here. We have a president that has conversations that have been distorted. We have a president whose communications with the vice president, the Department of Justice, with his own, citizens, those have all been manipulated and distorted by Jack Smith. And so that distortion is okay when you have a judge and a jury, but the Supreme Court is saying, well, hold on. You have to actually analyze this according to our constitutional principles, because it's so important that we not allow for routine prosecution of the president, whether he was for acts that are official or constitutional.
So I don't. This is so fascinating, Brett. Like, forgive me for just coming at this from a layman's community college graduate's perspective, but isn't this Minority Report? Isn't this like, we've seen what you saw, what you wanted to do in your soul, right? We've looked into your soul and we've divined through our magical powers what Donald Trump was thinking. Is that what they're arguing here?
Yeah, it's a great point. What Jack Smith is attempting to do is to put his own interpretation of what Donald Trump did and put it into an indictment, make it read like something conspiratorial, make the public and your friendly judge, and then potentially your jurors, make them actually read it in a way that implies guilt without ever having to do the analysis that the Supreme Court says should have been done. And that is to carefully analyze whether or not something the president did while in office was unofficial, or even whether it was directly under his constitutional authority. And if that's the case, immunity is absolute. If it's unofficial acts, it is presumed. And that is a heavy burden that the government has to overcome, but they were never required to overcome that. The judge just took and accepted, never required an analysis of whether or not it was an official or unofficial act.
So what percentage of a win is this for President Trump? And how steep is now the incline that the Supreme Court, how harsh is the obstacle course that the Supreme Court has now set as a threshold for prosecuting or proving that something is an unofficial act? Again, it seems like magical powers will be required to try and set up this fact pattern.
I think an honest district court judge, thoughtful district court judge, after reading this opinion, is going to have a very intense and thorough hearing where facts and evidence are presented to overcome the presumption of immunity. So the government has almost an entire new case they have to present.
Wow.
But Benny, I would say it, certainly it's not 100% victory for Donald Trump, but I don't think realistically he or any of his team would have wanted, or they may have wanted, but I don't think they would have expected 100% win, meaning the Supreme Court says, we grant immunity, dismiss all the charges against him for any of his conduct. That was never going to happen. But it is a 90 or 95% victory, because especially, and I rate it that high, because let's look at one of the facts where the Supreme Court gave an opening to Jack Smith. He said, when Donald Trump had the conversation, the court said when he had the conversation with Vice President Pence, and he's telling him to reject the electors, that wasn't clearly under his constitutional authority. So it's not absolute immunity, but it might be official. But there are some aspects that may make it unofficial, and the court needs to determine that. And I say, if you understand that opening, but then look at what happened in the Fisher case, the evidence of his conversation to Vice President Pence was directly was the direct evidence on the obstruction of an official proceeding. So when you read it in the context of their most recent decision in Fisher, where they absolutely gut the use of the obstruction angle that Jack Smith attempted to do, then you say, okay, even if it's an unofficial act and he doesn't have immunity, and that evidence can be admitted against him, it goes to the obstruction case. And the Supreme Court already said that's a case you cannot bring Jack Smith. So in that regard, that's why I rate it as high as I do, because both of those decisions, when read together, is an absolute bloodbath on the prosecution by DOJ.
That is such an interesting point. And because Fisher happened on Friday, we weren't able to properly digest everything
Yes.
for the show. We had a show built out around the debate and not around Fisher. And so, can you please give us just a 35,000 foot perspective of how these two join together to make this prosecution damn near impossible now?
Yeah, absolutely. The 1512 angle, that's the statute that Jack Smith attempts to use. 2 out of the 4 charges against Donald Trump are steeped in section 1512. What that is a very simple statute that said if you destroy documents, or you forge documents, or you do any otherwise do something with documents in order to manipulate or to obstruct an official proceeding, then that is a potential crime and a potential felony that could be brought. But the Supreme Court said it's limited to those documents. It comes from the Enron case when individuals started burning and shredding all kinds of documentary evidence. So Congress said, if you do that kind of stuff, then and it's in response to an official proceeding, then that can be an additional crime. The Supreme Court said that does not apply outside of the illegal use or the unlawful use or destruction or manipulation of documents. So the Supreme Court basically gutted the most important charges in the 4-count indictment that Jack Smith brought against the president. Now, when you overlay what they just ruled on immunity, you have to start to feel like the room is just closing in on Jack Smith.
Hmm.
And it should, because everyone on the left will scream, but they're not rooted in the law. They're not rooted in our constitutional separation of powers or our constitutional protections. And those 2 decisions will go down in history as quite phenomenal and important going forward to slap any president, Republican or Democrat, that unleashes multiple attempts to prosecute their political opponent. So I see those 2 as a phenomenal bookends of preserving our Constitution in a way that we were dangerously close to losing.
That seems like such a remarkable generational win.
Yes.
And for the next 100 years of the American Republic, if we can keep it. And so, like, what an optimistic outlook. Final question for you, really quickly here, because it does seem, if we're talking optimism here, Brett, it does seem that a lot of things are going right now. And if you were to believe the betting markets, the smart money is on Donald Trump winning and winning quite decisively on election night in 2024. Now, not to get ahead of ourselves, but hypothetically, what happens to these charges when Donald Trump becomes president again?
Yeah, it's a great question, Benny, and I've been thinking about this because I don't know if they will fizzle and they'll fall apart in sort of that transition from if Donald Trump wins. What does the Department of Justice do? I mean, remember, it is driven by bureaucrats. The administrative state is probably the most significant in the Department of Justice of any organization. So I if there's a case to be preserved, I think they'll continue. They may be trying to get the judges that are ruling on these, try to get them to identify unofficial acts that's evidence they can use, and they might continue to pursue them. But day one, if Trump wins in 2025, that first day, the new incoming attorney general or the acting attorney general that is appointed by the president will dismiss those cases. There's no question in my mind. I would like to see that
Wow.
happen. I would like to see that dismissal happen instead of Donald Trump having to grapple with the decision on issuing clemency to himself. I think that would be uncomfortable. I don't think he would really like to do that. I think he'd like to see it just go away. And if DOJ were authentic right now, if they were very thoughtful in their analysis after these two rulings, there would be a dismissal of the case in DC.
Hmm.
Jack Smith would file a document, and in that document it would say, in the interest of justice, the United States moves to dismiss the indictments against Donald Trump.
Hmm.
That would be the only document that should be filed at this point after the rulings by the Supreme Court.
Incredible. Just a very quick follow up there. You believe that the 2025 inauguration, January 2025, that first act, these are gone.
These yep. The two federal cases should be dismissed. I don't know what's going to. Florida is very interesting because there is certainly enough conduct that they've alleged outside of when he was president, but there are acts that occurred while he was president relative to the classified documents that do seem to suggest that they may have to grapple with immunity, some portion of it, at least in that case as well. But yes, both cases, day one, should be dismissed immediately. And then, he can't pardon himself for a state crime conviction, but certainly he would have time to, pursue the appeals, let the Supreme Court analyze the heaping pile of trash that was the Alvin Bragg's case. And then, Fannie Willis's case should fall apart. It's more akin when you're a kid and you tried to find Legos to build something, but they didn't quite fit. Let it fall apart because they don't fit and it doesn't function.
Something that does function quite beautifully and something that is really taking the country by storm is Right on Crime, Brett's group. It is a wonderful group, and it's so important right now to look at our judiciary and to look at the power there and to support the people that are fighting to ensure that we have constitutionalist, clear-eyed judges. And you can see the results of that today. Please go and support Brett's group. Support Brett by following on X for more razor-sharp takes here. And Brett, thank you so much. Running with the Stampede. I love that. I love that X header right there. You have the wind at your back, sir.
Thank you, Benny, for everything you do and the voice you are right now. Very important.
Godspeed, sir.
Thank you.
All right, Will, I was filibustering there for like a second just to give you a chance to sink your teeth into this ruling. And now, please, the floor is yours. What does this mean for Jack Smith's case against Donald Trump and presidents going forward and their ability to serve in that office?
I'd characterize it as maybe a 95% win for Donald Trump in the sense of if you imagine what he's asking for as his ideal outcome, he got about 95% of it.
Wow.
And so it's a major W. The bottom line of the impact on Jack Smith's prosecution is that there is absolutely no chance that they will be able to pull off a trial before the election. And that the court found basically it has three levels of analysis. First, it said, let's talk about the powers that are explicitly granted to the president in the Constitution. Things like the power to declare war, the power to issue pardons, things that are just like clear, vested in the executive branch. Court said for those, there's absolute criminal immunity. There's no chance at all. There's no way at all you can prosecute a former president for those acts. Mm-hmm. Then it talked about the more broad categorization of official acts, and that includes a lot of things. Things like talking to your vice president, getting advice, thinking about, the law, there's a much bigger category of just generally official acts of the president. That includes a lot. That includes much of the conduct that Trump is alleged to have engaged in the indictment. There, the court found that there is a presumptive immunity, that if that's an official act, the president is presumed to be immune unless prosecutors can demonstrate that prosecuting a former president that will not intrude on the functions of the executive. So the idea, the overall thesis, the reason that they issued this decision is they say the executive does a lot of things. It has its tentacles all over our government. It is key to its functioning. If the threat of future prosecution for anything will intrude on the functions of the executive, make them hesitant, make them not, do their job, then there can't be a prosecution for that. So, and then there's the third layer, which really already everybody agreed to, including Trump's lawyers, which is unofficial acts, things that the president does in his personal capacity, like testifying in a deposition and lying, for example, the way Bill Clinton did all the way back when he was president. Those unofficial acts have no immunity, but everybody already agreed to that. That's not a loss. That Trump's lawyers conceded to that from the outset.
Can we go back to point number 2 that you just made?
Yeah.
Because that does seem to be the murky territory that they're attempting to bring these January 6 charges against Donald Trump on. Like, you made phone calls and you asked people certain things and you tried to do certain things with Mike Pence and so on. What you're saying is that the court's ruling that there's no way you can bring charges against a president if he's just attempting to do the job of the presidency and if he's weighing and balancing certain options, which does seem to be exactly what they're going after Trump for. Just the questioning, right, of what options he had seems to be what they are hanging their hat on the criminal charges here. Again, I'm no lawyer.
Yeah, no, I think you're right about that. And I mean, you got to understand what this means in terms of the prosecution and given this finding. So what the court did is essentially what they call reverse and remand. They said, we're reversing the holding of the DC Circuit, which said that presidents have no immunity at all. And we're remanding for further proceedings at the district court level. And the district court, before the prosecution or before the trial begins, will have to have an evidentiary hearing to discuss whether or not the conduct alleged in the indictment are official acts. And then if they are found to be official acts, whether or not they are entitled to presumptive immunity. Right, the presumptive immunity that the court outlined. So that's a 2-step process, right? First, is it official? Second, if official, is it entitled to presumptive immunity? And that's before the trial. And then when that happens, Donald Trump can then appeal those 2 questions. Is it official? Is it entitled to presumptive immunity? So that's why I say, we've got, I saw Oren Kerr say years of litigation before you could conceivably get to trial on anything alleged in the indictment, because you're talking about the district court's going to have a hearing with all the briefing entitled, make a finding. That finding is immediately appealable before trial because we're still in the phase of immunity, right? If you can't have pre-trial immunity hearings, then there is no immunity. Effectively, it defeats immunity. The idea is you shouldn't even have to sit for a trial if you prevail and have immunity. So, yeah, I mean, it's a big W for Donald Trump. It didn't go quite as far as he wanted. His lawyers presented the position that he should be absolutely immune for all official acts unless he's impeached and convicted for them. The Supreme Court said, no, it's only presumptive immunity for the broader category of official acts. And there are circumstances in which you could be prosecuted for those official acts, but you still have to go through this whole analysis of whether or not prosecuting a former president would intrude on the functions of the executive branch.
So what you're saying is they didn't give Trump 100% victory. A 95% victory means that you've created so many gates and such a steep incline to try and make this case. You've presented effectively a 90-degree incline that you must roll the stone up to try and create a case against a president. That's
a really good way of thinking about it, right? You created a huge obstacle course that a prosecutor has to surmount in order to bring a case against a former president for their official acts. And odds are that you won't.
Really important question, Will, here, given the greater overall landscape that seems to be delivering W after W to Donald Trump. What happens if a current president is being prosecuted in an immunity case? Donald Trump is victorious, and what happens then, right, to this case?
Well,
where does it go?
If
right?
Donald Trump prevails, that at a minimum, all the prosecutions against him will be stayed. They'll be stopped because there's an OLC opinion that says the Department of Justice cannot prosecute a sitting president. And that's just a basic understanding of the fact that the Department of Justice reports to the president, so they can't prosecute their superior. That's not how our government functions. So if President Trump wins the election, tack on to every other delay the fact that as long as he's president, DOJ can't do a thing to him. And I think there's a reasonable chance that a DOJ under President Trump would simply announce that the prosecutions are shelved, and there may be a way to just simply bury them outright and not allow them to continue.
Yeah, I mean, we've heard speculation about that. What about going back into the legal theory here? Has any president, is there any basis to say, yeah, a president can contest an election? Like, yeah, this happened here.
Well, so the president, for example, one of the things I didn't get a chance to read the full opinion, right? I'm kind of reading the syllabus and extrapolating, but I did notice a section that dealt with, a president is allowed to work with his attorney general to discuss prosecutions for election fraud, right? And that's within his power. That's an official act. He can't be prosecuted. And another thing that they said is you're not allowed to look at the president's motive when you do this analysis. It's not, so you're not allowed to say, well, he had improper motives. He was doing it for his own personal political reasons. Doesn't matter. The question is that's totally irrelevant. The question is whether or not for the question of immunity, it's whether or not the power being exercised or the thing he was doing was itself an official act, was part of his job. And if so, yes, then there's going to be at a minimum presumptive immunity. So I think that I don't think that really there's going to be at the end of, if for example, let's say, God forbid, President Trump loses the election in November and this prosecution continues over the next 3-4 years, I think even at the end of all that, when you've sorted out all the immunity issues, there will be almost nothing left of this indictment.
Wow.
That's my guess.
So completely atomized, completely eviscerated.
Yeah, I mean, just from my quick skim of the kind of things that they're saying would be official acts and the kind of test they're applying and how the court is thinking about it, it suggests to me that the Jack Smith prosecution is basically dead in the water.
Wow. Okay. Well, thank you for coming on and stating with such clarity what's truly happening here. The Article 3 project, obviously, you are all familiar with it. Make sure that you support the Article 3 project, the work that they're doing. They're changing the landscape of the country, and also support Will, who has an awesome following himself and has some of the sharpest takes. You could be careful around Will's takes. You cut your finger on them because they're good. They're good, right? They're very clear-eyed, and just like what we would expect from the Article 3 project. Godspeed, Will. Everyone go over there, follow 333,000 followers. Come on. Come on, baby. On to 1 million. Will Chamberlain, Godspeed, sir.
Thank you.